Welcome to the DX Today podcast, your daily deep dive into the AI ecosystem. I'm Chris, and joining me as always is Laura. Today we are digging into a federal appeals court decision that landed yesterday and may quietly reshape the entire agent economy.
I have been genuinely impatient to talk about this one, Chris, because it is the rare court ruling where the legal reasoning and the technical reasoning actually line up with each other instead of fighting.
Set the table for anybody who has not been following the case, because the backstory here stretches back the better part of a year, and it involves two very large, very well-funded companies.
Back in November of 2025, Amazon sued Perplexity over its Comet browser, and specifically over an optional agentic feature called the Assistant that can log into your Amazon account and shop on your behalf.
Let's be precise about what that feature actually does, because I think a lot of people hear the phrase shopping agent and picture something much more autonomous and much scarier than what is really happening here.
You install Comet, you log into Amazon yourself with your own credentials in your own browser session, and then you can ask the assistant to compare products, check prices, read reviews, and in some cases, start a purchase.
So the human is signed in, the human owns the session, and the agent is essentially operating the controls of a browser that is already sitting on the user's own machine and already authenticated.
Exactly right, and that architectural detail turns out to be the whole ballgame. Because Amazon's legal theory required the court to believe that Perplexity, the company, was the one reaching into Amazon's servers.
Which statute did Amazon reach for here? Because I have a suspicion, and if I'm right, it explains why the civil liberties community got so loud about this case so quickly.
You are right to be suspicious. Amazon sued under the Computer Fraud and Abuse Act, the federal anti-hacking law, plus California's state equivalent, the Comprehensive Computer Data Access and Fraud Act.
That federal statute has a long and honestly troubled history of being stretched well beyond the mainframe intrusions that Congress originally had in mind when it passed the thing back in the 1980s.
It really does, and the critical thing people forget is that it is a criminal statute first. Civil claims ride along on top of a law that can put human beings in prison.
And the Supreme Court already tried to rein this in a few years ago in the Van Buren decision, which read the authorization language narrowly rather than letting it swallow every terms of service violation.
Correct, and that narrowing instinct is exactly the thread the Ninth Circuit picked up here. But before we get to the appeal, we need to talk about what happened in the district court, because Amazon won round one decisively.
Walk me through that, because if I remember correctly, the trial judge did not just find the claim plausible. She found Amazon likely to win outright, which is a meaningfully higher bar.
Senior District Judge Maxine Chesney granted a preliminary injunction on March 9th of 2026. She found strong evidence that Comet accessed the user's password-protected account with the user's permission, but without Amazon's authorization.
That phrasing is fascinating to me because it draws a very sharp line between the permission you give and the permission the platform gives. And it treats the platform's consent as the one that legally counts.
That is precisely the fault line. Her order also emphasized that account information was being transmitted to Perplexity's own servers in order to carry out the tasks the user had requested from the assistant.
What did the injunction actually forbid in practical terms? Because there is a big difference between shutting down a whole product and carving out one narrow slice of its behavior.
The order blocked Comet from touching Amazon's logged-in, password-protected account pages. The browser survived, but the single most commercially interesting thing the assistant could do on the largest store on the internet was switched off.
And then the appeal machinery kicked in, which usually takes forever, but my understanding is that this one moved unusually fast for a federal appellate case of this complexity.
It moved very fast. The Ninth Circuit stayed the injunction while the appeal was pending, heard oral argument in Seattle on June 11th, and issued a published opinion yesterday on August 4th of 2026.
Tell me about the panel, because in a case this novel, the composition of the three judges genuinely matters, and people will read the politics into it, whether that is fair or not.
Judge Milan Smith Jr. wrote for the panel, and he is a George W. Bush appointee. He was joined by Judge Eric Tung and by District Judge John Hinderaker of Arizona, sitting by designation.
So a Bush appointee and two Trump appointees vacated an injunction that a Clinton appointee had granted, which should complicate anybody's tidy story about how judicial ideology maps onto technology cases.
It should complicate it enormously, and I think that is one of the underrated signals here. This was not a panel looking for an excuse to help a startup. They just read the statute closely.
Give me the core holding in the cleanest possible language. because I suspect it is going to get quoted in every agent company's legal memo for the next several years running.
Here's the line. It is the user who accesses Amazon's computers, with the help of the assistant to carry out specific acts on Amazon.com. Perplexity, the company, never gains entry at all.
Okay, but let me push back the way Amazon's lawyers surely did, because Perplexity is not exactly a passive bystander in this arrangement. Their servers are receiving data and issuing instructions in real time.
The panel addressed that head-on, and I think this is the strongest paragraph in the whole opinion. Perplexity may receive screenshots of the user's browser and may communicate instructions to the assistant.
And the court's answer to that was what exactly? Because on its face, that sounds like meaningful involvement rather than the company simply handing someone a hammer and walking away from the job site.
The court said those activities by themselves do not mean that Perplexity has accessed, meaning gained entry to, Amazon servers. Receiving information about a session is simply not the same act as entering it.
There's another line in there I want you to unpack, because it seems designed to head off years of philosophical argument about machine intent before that argument can even properly get started.
You mean the holding that the assistant is a tool, not a person for statutory purposes? That single clause lets the court skip every thorny question about whether an agent can form intent.
Which is either elegant judicial minimalism or an enormous dodge, depending entirely on your priors, and I honestly cannot decide which of those two readings I find more persuasive this morning.
I lean toward elegant, and here is why. Courts get into terrible trouble when they invent sweeping frameworks for technologies that are changing monthly. Deciding the narrow question is the responsible move.
Let me play devil's advocate anyway. Does this ruling not create a fairly obvious loophole where any company can insulate itself simply by routing its automation through a piece of software the user technically installs?
That is the sharpest objection to the decision, and I want to take it seriously. But notice that the court leaned on the rule of lenity, which is a doctrine about criminal statutes specifically.
Explain why that doctrine is doing so much work here. Because I think most listeners have never had a reason to care about how ambiguity in a criminal law gets resolved.
When a criminal statute is genuinely ambiguous, courts construe it against liability rather than in favor of it. And the panel noted that Amazon's broad reading could expose users themselves to criminal liability.
That is the detail that stopped me cold when I read the coverage, because it means Amazon's theory did not just threaten Perplexity as a corporation, it threatened ordinary shoppers with federal exposure.
Right, because if using an unapproved tool to visit a website you are already entitled to visit counts as unauthorized access, then the person who clicked the button is potentially a criminal defendant.
The Electronic Frontier Foundation filed a brief in this case, and I gather the panel found their technical explanation unusually useful, which is not something you see acknowledged in an opinion every day.
The court wrote that the Electronic Frontier Foundation's explanation articulates the nature of the system most clearly. That is a real compliment, and it reflects how much this case turned on technical architecture.
What happened to the California claim? Because state computer crime statutes are often drafted more broadly, and I would have expected that to be Amazon's stronger fallback position on appeal.
Amazon argued exactly that the state definition of access is broader than the federal one. The panel said even so, the focus remains on the person accessing or causing the access.
So both claims collapse for the same structural reason, which suggests this is not a narrow drafting quirk, but a genuine conceptual problem with applying entry-based statutes to delegated software.
And the panel did not stop there. It also reversed the district court on irreparable harm, on the balance of equities, and on where the public interest actually lies in this dispute.
Now, how narrow is this holding, really? Because I have already seen people online describing it as a green light for agents to go anywhere they please on the open web.
Those people did not read the opinion. The panel expressly limited itself to the access prong on this record and said flatly that it does not establish a new legal regime governing agentic AI.
There's also a remarkably candid admission in there about how little law exists on this question, which I found refreshing coming from a federal appellate court that could easily have pretended otherwise.
The court acknowledged there is little to no existing case law directly dealing with how to ascribe responsibility for AI agents like the assistant, let alone case law specifically dealing with agentic AI in this context.
So what actually survives for Amazon here? Because vacating a preliminary injunction is very different from throwing the entire lawsuit out of federal court on the merits once and for all.
The case goes back to the district court, and Amazon's trademark claim plus its remaining state law theories are all still very much alive. This was one prong of one claim decided at an early stage.
Let me steal an Amazon for a moment because I think their underlying concern is more reasonable than the statute they chose to vindicate it. And that distinction is worth drawing carefully.
Please do, because I think the company's public position is actually defensible. Amazon says automated agents that access its store and private account data on behalf of customers should transparently identify themselves.
And that is a genuinely sensible ask. A retailer has real interest in knowing whether it is serving a human or a machine, for fraud detection, for infrastructure load, and for pricing integrity.
There is also an economics problem underneath all of this. Amazon's entire recommendation and advertising apparatus assumes a human is looking at the page, and an agent that comparison shops silently destroys that assumption.
So the commercial stakes are enormous, and I suspect that is the real fight, with the anti-hacking statute serving as a convenient legal instrument, rather than the actual heart of the dispute.
That is my read too, and it is worth noting that Perplexity was valued at $21 billion as of earlier this year, so this is not a scrappy garage startup being bullied.
What did Perplexity say publicly once the decision came down? Because I imagine the messaging was carefully calibrated to sound like a principle, rather than simply a corporate win in litigation.
Their chief communications officer, Jesse Dwyer, said the company will continue to fight for the right of internet users to choose whatever AI they want, which is framing this as user autonomy.
For the builders listening right now, what should they actually take away from this? Because I want to be careful not to let anybody walk away with dangerously false confidence about their legal exposure.
The honest takeaway is narrow. Federal anti-hacking law is probably not the weapon that stops user-directed agents. Everything else in the platform's arsenal is still fully loaded and still very dangerous.
Spell out what is still in that arsenal, because I think that list is considerably longer than most people building agent products this year have actually stopped to think carefully about.
Terms of service and breach of contract claims, trademark claims, unfair competition theories, trespass to chattels, and above all, the simple technical option of detecting and blocking agent traffic at the edge.
That last one worries me the most, honestly, because it means the resolution of this whole conflict may end up being determined by bot detection engineers rather than by judges or legislators.
An arms race is the most likely near-term outcome, and I would argue it is the worst one, because it burns enormous engineering effort on both sides and produces nothing users actually want.
Is there a version of this that ends well? Some kind of negotiated protocol where agents identify themselves honestly and platforms agree to serve them under clearly published and predictable rules of engagement?
That is the outcome I would bet on eventually, and there is already serious standards work moving in that direction. But standards take years, and litigation and blocking are available right now today.
Last question for you. If you had to name the single most consequential sentence in this entire 21-page opinion, which one would you point people toward reading for themselves?
The tool, not a person line, because every hard question coming at us about agent liability, agent contracts, and agent responsibility runs straight through whether the law treats these systems as instruments or actors.
That is a perfect place to land, and I suspect we will be revisiting that exact question many times before this case even gets back in front of the district court judge.
We absolutely will, and I would just remind everyone that the Ninth Circuit itself said the legal understanding of agentic AI will doubtless change. They know they are writing the first draft of something.
A first draft that a lot of very expensive lawyers are going to spend the next year arguing about. That's all for today's episode of the DX Today podcast. Thanks for listening, and we'll see you next time.